All rise. Court is open. Please be seated.
All right, we are back for our fifth and final case of the day. Thank you for your patience. The case is 25P 915, CRG Acquisition versus members of the Holliston Planning Board. And I do want to note that we have a reconstituted panel here with Justice Sabita Singh to my right, Justice Robin Toone to my left, and I'm Peter Sachs. So with that, Mr. Tallerman?
Yes. Good afternoon, Your Honors, and may it please the Court. Jason Tallerman on behalf of the town of Holliston. With me is Stephen Chaplin from my office. So this is a zoning case regarding deference to a local interpretation of a zoning bylaw. And I'm not going to sit here and claim that the bylaw in question, and it's really 7 words in particular, are a model of clarity and precision. I've been doing zoning and municipal law for 30 years, and I know that there's a fair bit of bylaws out there that lack the kind of precision that we might like. And the land court acknowledged as such, that there were difficult language choices here. But regardless of whether the language may be a little muddled or susceptible to varying interpretations, the standard still applies. And that standard is deference.
So does it apply? That's one of the issues about 240, Chapter 240,
Sure.
14A, and there is some law out there sort of saying maybe it doesn't, unlike the other statute.
Right.
So can you just?
Well, I was going to save that for last, but
Let's
let's just get
first.
right into it, Your Honor. First, as I was preparing for this, and we didn't include it in our reply brief, but it struck me that this same argument was pled below. And the court did not make a specific finding on it, but clearly applied the deference standard across the board. That hasn't been challenged in any way by a cross appeal. I note that just for the record here, to preserve the record. But I also don't think, as we state in our reply brief, that there's any body of law that's been definitive on the particular issue that is raised by my brother here. There's no case that squarely says the deference doesn't apply. There are a few scattered cases, including some non-binding cases, where they said in the face of a unreasonable interpretation of a local bylaw, then we're not going to apply deference. But that's the general standard anyway. As we cite to a number of cases, there's at least an implication that the deference standard still applies when there's companion 40A17 and 240-14A counts. And
Would it be possible that there's a rule that sometimes deference applies under 14A and sometimes it doesn't? Is that, or do you think deference always applies?
So I do think there are situations that arise where there's no opportunity for a local interpretation to happen, where someone is just seeking as an investment opportunity to get a view of what that bylaw may look like. However, even in that instance, there's no case that definitively says that the municipality's version of what they think that bylaw should be as a defendant in those cases is not entitled to some degree of deference, or at least, and we cite this with respect to the cases too, if the town makes that position that is somewhat contrary to the plaintiffs in that kind of more of a bald application of 240-14A, that it's still not an arbitrary and capricious standard, which you, as we suggest, you kind of tease out the deference standard as well. But the larger point that I'd make as someone who does zoning law every day, as exciting as that may be, is that think about the damage to the existing set of procedures and standards that we have out there.
You can run into court and get a better standard than if you go first to the board with your
Correct,
application.
and we think that is just genuinely problematic and would upset decades. If the court issued, the appeals court or the SJC issued a decision that said, hey, deference doesn't apply here, I'd be flooded with 240-14A cases before we ever got to an actual hearing before one of the boards that I represent. And I don't think that that is a workable solution. Do I think, again, in some situations where there's no case in controversy at all, and there's no companion 40A17 case, that it might be more of an even playing field going in? I do think there's some room for that, but that's certainly not the case here. And again, we don't have any specific guidance by any appellate court with respect to this.
Did the judge have to resolve this on the 14A claim? Could he have resolved it on count one? Is that, or did it have to be done through?
No, to me, it is conceivable that the judge could have ruled as to an interpretation of a bylaw under a 40A17 count. That happens all the time, that the way you're interpreting it. 240-14A doesn't require that case in controversy, so it can be reserved for those instances where you want to pre-bake or get a view of the courts when you know the town may have taken a different view. But yes, I mean, I have cases all the time before the courts where there's squabbles over interpretation of the local bylaw within the 40A17 context. So it can happen in either.
Well, thanks for addressing that. And I've got one more question. I know you're winding up to your big argument. Before you get there, can you just explain to me, and just in layman terms, I just don't understand what exactly happened here. The planning board unanimously approves CRG site plan in March 2020, then denies its application for a special permit in July 2021. So can you just, exactly how does that happen, where there's upfront approval and then a more narrowed application that gets disapproved?
So I will tell you anecdotally, because it might not be completely reflected in the record, the applicant made a choice to get the easier permit first, certainly here, which was the site plan approval. It's non-discretionary, and you can't really deny it unless you don't meet the underlying standards. But at all times, the communications by and between the applicant and the planning board was like, this is great, you need site plan approval. It is required whether there's a special permit required or not. But
Right, so the initial decision says, the 2020 decision says, well, the building inspector has expressed concern that ultimately the use may require a special permit. It's not the board itself saying, oh, by the way, you're going to need a special permit. It's kind of just flagging this.
But it was flagged to them that you're going to have to apply for this. And at all times, in fairness to CRG, the applicant, they said, we don't think we need it, but we're going to apply anyway. And that's what good developers do. Let's see how it goes. Let's try and break bread, make a good project. And the discussions, there's never been like incredible loggerheads here. They've behaved appropriately at every step of the way and tried to win over the board. Ultimately, they weren't able to do. It was not particularly rancorous in terms of the relationship.
You're saying the board didn't behave badly here too? It didn't kind of pull the rug out?
I don't think there's
no
any
expectation that they were going to,
yeah, I mean,
with the 2020 decision, get this thing
yeah,
built.
no, I mean,
special
might there be some tension with a super large project being proposed next to a residential neighborhood? Sure, there's always going to be tension on that, but I think everyone behaved more. There was a lot of peer review. There was a normal process. I'm sure there was frustrations on both sides. In fact, I know there was because I was there for a lot of it. But it was a pretty normal process. And at all times, they preserved their rights, and at all times, we preserved our rights. So that I think all went according to plan. So let me get through this a little bit, because I think this starts with our view of it. Our view of the language is, and the 7 words are, in the G1 in the use table, wholesale office or showroom, comma, that's my emphasis, including warehouse facilities. That's it. That's the language. And there's differing interpretations on that, of course. Of course, our position is that you can do a showroom or a wholesale office, and if you want to include attendant or accompanying warehouse facilities, great. If you don't, then fine. But it's not a standalone. It has to be connected with that. Of course, the other side has a different view. And what it comes down to, in a way, and the judge highlighted this, is what do you do with the term including there? Now, we think the comma is important. We think the word facilities is important. That's all in our brief. And the judge even recognized that there are 2 kinds of use of the term including. Either it's the use that we suggest, where, no, these are the 2 uses and you're allowed to include this other one if you want, or is it an attempt to create an illustrative list as to what would be a warehouse or a wholesale showroom or office, and that could include a warehouse. So
Warehouse facilities.
yes, warehouse facilities. Now, I was trying to think of a good way to come up with an example of what that would look like in kind of more generic terms, because again, the language is a little bit muddled. And, you know, forgive me if I will, but if I said I wanted to go buy a box of cereal, including a special prize inside, that's kind of our interpretation. It's a box of cereal and it includes something pretty cool inside. Or if I say, I'm going to go shopping for a box of cereal, including Captain Crunch or Corn Flakes, then that's the list. Now, the judge recognized that those are both reasonable general interpretations of the word including. Now, we think it should end there because in the choice between two conflicting views, you have to defer to the board. The judge did not stop there, though, and the judge started to pick apart other language. And we think the judge's picking apart of that other language is not really reasonable and in many cases not logical. For starters, the judge went and became somewhat preoccupied with the definition of warehouse. And he essentially took the position that the definition of warehouse essentially means that there should be a standalone primary use. However, there's nothing in the Zoning Act, in the local bylaw, or in any case that I've ever read that says a mere definition of a use has to then carry forward to the use table itself. That doesn't exist. That's not a part of any zoning act or anything like that. You could mention it or not.
But why define it?
Well, we define it, and because it could be important, or maybe it's future thinking or what have you, but here we do use the term warehouse facilities, and this is where the second part of the failing of the judge's interpretation comes up. He says, well, if you're going to say it, then it must be a standalone use. Well, that's not necessarily true. You can have it be an accessory use or an accompanying use, which we suggest is the case here. The definition is still helpful. And then the judge turns to the notion, well, it says a building primarily used for the storage of goods and services. So he said, well, if you're using the word primary, then it must be a primary use. Well, that's not. That's conflating two different terms. For example, a zoning bylaw could define an accessory garage that most of us have next to our house as primarily being used for storage of vehicles. That doesn't make it a primary use. It's just saying that's what you're going to primarily use it for. And so it's different than primary and accessory uses.
What do you make of the fact that this provision says warehouse facilities as opposed to warehouse?
Well,
which is what's different?
I think that every word's important. And if they wanted to make it a list, then why use the comma, why use the term including, and why use the term facilities? Yeah. They could have just said a warehouse. But to me,
the position would be weaker if it said including a warehouse.
Yeah, it's including warehouse-like facilities. So we think that, and this is kind of another aspect where I think the judge loses the thread a little bit here, it doesn't matter. He gets hung up on primary use or accessory use. Nowhere in those 7 words that I read before in the use table does it say in any way, shape, or form that it has to be lesser or larger or accessory. It just says that you can have accompanying, it doesn't use the word accompanying, but you can have including warehouse facilities. That means you could have, I suppose, 1,000 square foot showroom and a 10,000 square foot set of warehouse facilities, but it doesn't have to be accessory, which is normally lesser. They don't use that term accessory. He's reading that into this in a way that the language doesn't support.
I wanted to ask about the judge's statement that 3G1 is the only place in the bylaws that warehouse appears.
Okay.
I stumbled on another use of it in 3D11, mixed office and warehouse use, where not more than 20% of the gross floor area, not to exceed 15,000 square feet, is devoted to warehouse facilities, packaging, or fabrication.
Right, so it does exist elsewhere, but I think that that's kind of a red herring in a way because it's obviously used here. But the board has also interpreted it as being allowed by special permit in the general industrial use thing. In fact, where it uses this
Oh, I don't
very
mean to
similar
suggest,
term.
I don't mean to suggest that 3D11 is the exclusive provision for warehouse use or warehouse facilities. I guess what I'm asking is, does the use of the term warehouse facilities in 3D11, provided that they don't exceed 20% of the gross floor area or 15,000 square feet, suggests that the definition of warehouse as a building primarily devoted to storage doesn't necessarily govern what warehouse facilities means, because warehouse facilities here is clearly used as a portion of, not to exceed 20% of the floor area.
Regardless, the town has a definition, and then they implement it through the use table, which can then have qualifications to it, which if they're more narrow than the definition, then the narrow is going to control there. But it's not like the town is like saying, hey, we created this definition, we don't want to ever allow warehouses. They do allow them if they're attendant to or accompanying a showroom or a wholesale office, or, as the record clearly reflects, they have taken the interpretation that you can do it by special permit, which was the case here. So they're not shutting out warehouses. They're not ignoring the fact that it is a defined use. It's just not used in the very, very narrow sense that we think the trial court had.
But just to be clear, you agree with what Justice Sachs is saying here, that this other reference to warehouse facilities supports your position that
Exactly.
it's not limited by the definition, the primarily part of the definition.
100%.
Okay.
Yes, 100%. And if I may, and I know I'm over time already, there was one other element of the judge's reasoning that I find to be interesting, and I think having some flaws in it, is he was hung up on the fact that it says in the definition that there's no sales in warehouses. Well, I don't think that's really relevant, because if you have a warehouse accompanying a showroom, okay, no sales in the warehouse element, fine. If you want to do sales in your showroom, okay, but you just can't, it's not a retail operation where you're doing sales within the warehouse itself. I just didn't think that the judge's position in that carries through necessarily logically as somehow a barrier to the board's interpretation of the warehouse in the way that they've interpreted it. So with that, yeah, sure.
So you started by talking about how the board has a reasonable interpretation.
Right.
And that's all that's necessary. And I'm following your reasoning, and then you get to the overall logic of your interpretation is that we're talking about less intensive uses, and then you need special permits for more intensive uses, right?
Correct.
And your brother makes the argument that a simple warehouse would be, is there anything less intensive than that, a simple warehouse to store items?
Well, intensity could be viewed in a number of different ways, Your Honor, and I would say that while it is can be a fairly quiet use, there's two things I would point out there. One, they can also be gigantic. They can be huge. Here, 800,000 square feet. But a warehouse also is not necessarily a kind of inert, quiet, just storage use. You drive past, and we probably all do at some point in time every day, an Amazon warehouse facility, and they are hubs of activity with thousands of truck trips a day. So in terms of both the size of it and the potential for upheaval in terms of overall truck trips, then I do think that on the scale that the board is talking about in kind of the cascading thing from G1 to G2 to G3 in the use table, that there's logic and reason to that. Might there be some warehouses that are incredibly quiet and they're just deep storage? Sure. But that doesn't mean the board's interpretation in terms of that kind of cascading effect from the by right use to the small warehouse use or the small industrial use to the large industrial use has no reasonableness to it.
Thank you.
All right.
Thank you.
Thank you. We'll hear from Mr. Pinto for CRG.
Good afternoon, Your Honors. May it please the Court, Donald Pinto for the appellees. My brother wants the case to be about deference, and it's not for two important reasons. First, the notion of deference is something that arises in zoning appeals under Chapter 40A, Section 17, where there's an underlying zoning decision by the zoning board, and the notion is that zoning boards are presumed to be more familiar with the local zoning bylaw, so they should, their view of the bylaw should be given some extra weight. Every case cited by the appellants and every case I've found where the deference concept was used by a reviewing court involved a decision under Chapter 40A-17 where the local board board commits in writing to some interpretation, and then it gets reviewed.
But would it make sense to allow an applicant to escape that deference by going under 240-14A and then preclude the board from giving its view, even if it's for the first time, because the applicant never went to the board, just went directly to court? Why should an applicant be able to get a better interpretation by going directly to court?
Well, it's not going to be necessarily a better interpretation. It's just going to be
less deferential
one
interpretation.
that doesn't defer to a local interpretation. Right. But again, you have to start with a local interpretation, and here there is no local interpretation.
Why can't you use the local interpretation that's proffered once the applicant brings a 240-14A claim?
You mean the litigation interpretation? Yes. Yeah. Well, that's just not what the what the case law has looked at. And again, I have not found a case where there wasn't a local interpretation in writing that the court was then reviewing and deferring to. I would liken this to what I would call a clean 240-14A claim where there is no local interpretation. The planning board approved the site plan and didn't interpret the bylaw. All they said was the building inspector expressed some concern that this use might need a special permit, and if it does, the applicant will have to come back to the board. In its denial of the special permit, it didn't even mention the interpretive issue, didn't mention that section of the bylaw.
Didn't you apply for a slightly reduced scale site plan, which was denied, and that's when you initiated this litigation?
Yeah, that's correct.
So was it denied based on, what was the basis of that denial?
It was, the basis of the denial was, in the board's view, failure to comply with the various criteria for issuance of a special permit. So it assumed that a special permit was required, but it didn't speak to that, didn't explain or espouse an interpretation of the bylaw. It apparently was still relying on the building inspector's concern that
what's the difference between a determination by the board that kind of is based on this interpretation and its articulation of that interpretation in a brief in the land court, right? It seems like an artificial, you're trying to sort of say, well, deference only comes if you articulate these reasons before you get to court.
Again, that's what the case law suggests, is that the reason for deference is because the local board in the administrative process has espoused an interpretation, not that a clever lawyer like my brother on a summary judgment motion comes up with an interpretation then. It's supposed to be a genuine local interpretation. In many cases, they're long-standing local interpretations. There's evidence of that at the trial court level, and that's why it's entitled to deference. I hasten to add, though, that here the deference issue is beside the point. Judge Speicher, mistakenly, in my view, cited the deference cases in his decision, but he went on to find that the board's decision, or rather the board's interpretation, is unreasonable. And the case law says if there are two interpretations, they both have to be reasonable for there to be deference. So Judge Speicher said he cited the deference standard and then found the board's interpretation to be unreasonable, and I think he was correct in that for three reasons. We've touched on some of them. First, warehouse is a defined term in the bylaw. It appears in section 3G1, the key one we're talking about. It doesn't appear in sections 3G2 or 3G3, which the board contends are the applicable sections. Those sections don't mention warehouse anywhere. They talk about general industrial uses. And I think a warehouse for the passage, storage of goods and materials is not a general industrial use as defined by the bylaw. Secondly, we touched on this, warehouse is defined as a building used primarily for the storage of goods and materials. And if a warehouse is a building used primarily for that purpose, it can also be an accessory use in a building used primarily for a different purpose,
That may
like
be so,
wholesale
but what
office.
about a warehouse facility?
Your Honor, in my view, adding the word facilities doesn't change the underlying use, the underlying fact that it's a warehouse. Facilities just implies that there are, facilities. It's not solely a building. It may have a parking area, some loading docks for trucks to load and unload. So I don't think it changes the nature of a warehouse. It's just a broader term to encompass the reality of what warehouses are, which is not a single building, but a single building with amenities, lighting, parking, loading docks, et cetera. And then third, Your Honor, the definition of warehouse specifies that it's for storage of goods and materials not for sale on the premises. And the land court noted, I think correctly, that the bylaw defines wholesale trade specifically as involving sales of goods to other wholesalers or to other businesses. So if you interpret warehouse in 3G1 to include sale on the premises because of the definition of wholesale trade, then you get an absurd result where the bylaw is contradicting itself in violation of the rule of construction that the bylaw should be read as a harmonious whole. So the land court did that. It read the bylaw as a harmonious whole and found these internal contradictions and found the planning board's interpretation, litigation interpretation of the bylaw to be unreasonable.
What does including mean in section 3G1?
I'm sorry, I didn't
What does the term including mean in 3G1?
Right. Well, by itself, including doesn't mean anything more than that the things that went before are joined with the things that went after. It doesn't mean what the appellants say it means unless you add some word after including and before warehouse facilities. And the appellant's brief is rife with these adjectives that they need to insert, and they're asking the court essentially to insert after the word including. They say what it means is that the warehouse is accessory to the wholesale office or showroom, accompanying, associated, component, companion. These are all adjectives from the appellant's brief.
But do you have an explanation as to what including means? 'Cause it seems to me like you're interpreting this to mean wholesale office or showroom or warehouse facilities, right?
Correct.
And I guess that unreads including. I mean, I'm sorry, so what's your explanation of why the term including?
Yeah, see, I would disagree. It unreads including. I just simply view including to mean that the thing after the word including is included with the prior two things as a use that's permitted by right.
Is that a sensible interpretation? Is warehouse or warehouse facility ordinarily an example of a wholesale office or showroom? I mean, I think of a warehouse as a place where you have trucks pulling up and depositing merchandise or whatever and picking it up, and I don't think of that as an example of a wholesale office or a showroom.
No, I didn't mean to suggest there's some logical connection between the two by the word including, just that including means here's another thing that's included in this list of uses that are allowed by right.
But if it's an alternative that doesn't necessarily have a logical connection to wholesale office or showroom, why wouldn't the bylaw say or?
I can't answer that question, Your Honor, except that this seems to be, again, the least intensive category of uses wholesale office or showroom without any retail sales or sales of goods on the premises in a warehouse. They're all of a less intensive variety than the 3G2 and the 3G3 general manufacturing uses. Passive storage of goods and materials in a warehouse is more like a wholesale office or showroom in terms of intensity than the general industrial uses that talk about manufacturing processes that might happen in a factory.
So you you interpret including warehouse facilities essentially to mean or warehouse.
Yes, Your Honor.
Okay, and they interpret it to mean which may include warehouse facilities. Is that fair?
Well, it's not just that they may include warehouse facilities, it's that they may include a dependent accessory companion warehouse facility. Again, they have to insert an adjective in front of warehouse facility that makes it linked to wholesale office or showroom.
Well, facilities is plural. Wholesale office is singular, showroom is singular. So when they say, or when they interpret it as a reading wholesale office or showroom, which may include warehouse facilities, it seems to me they're saying that facilities is plural. It's not the third part of the series about wholesale office or showroom. It's some amenity that may be included in or with a wholesale office or showroom. Is that unreasonable? Sorry, I know that was a lot to respond to.
I don't view warehouse facilities to be different in kind from wholesale office or showroom just because it's plural versus wholesale office or showroom being singular. These things are drafted by lay people however many years ago, so I don't put a lot of stock in that.
So what about the provision in 3D11 that makes it a permissible use, I think in commercial areas? Mixed office and warehouse use where not more than 20% of the gross floor area, not to exceed 15,000 square feet, is devoted to warehouse facilities, packaging, or fabrication. Doesn't that indicate that although the definition of warehouse talks about a building primarily used for storage, this permitted use clearly envisions warehouse facilities, meaning something where not more than 20% of the gross floor area is used for storage.
I agree it's inconsistent, Your Honor, with the definition of warehouse that was put into the bylaw. And apparently when they put it in 2016, they weren't taking account of that other section that Your Honor is citing to see whether it's consistent or not.
Right, and so, I mean, doesn't the logical interpretation of warehouse facilities in 3D11 have something to do with how it should be interpreted in 3G1, which is the provision at issue here? Warehouse facilities perhaps meaning something different than warehouse, and something that is not fully governed by all of the terms in the definition of warehouse, such as primarily and such as not for sales.
Your Honor, I don't think because that other provision that Your Honor is citing was ever mentioned, talked about here, looked at by the land court. I think it's not helpful in interpreting warehouse as defined in 3G1, which everyone has agreed is the operative section of the bylaw. But again, a warehouse can't be a place where goods are sold on the premises, which again cuts against the planning board's litigation interpretation of the bylaw.
You can, though, just as a matter of common sense, have like a showroom. Say it's a plumbing fixture showroom that has in the back a warehouse facility where they can bring out more. If someone goes, is like, I want to buy that. Oh, we have one in our warehouse facilities that's attached, right? That is a thing that could be what they intended with this language, maybe?
It's definitely a thing, to my knowledge, that you can have an attached accessory warehouse, and that's exactly what the appellants are arguing to the court, is that 3G1 definition should be interpreted as if it included the word accessory or dependent or companion or accompanying or associated, and they have all different formulations in their brief, but they all boil down to the same thing. They're asking the court to supply that word, and the land court found that that was not appropriate, violated the rules of construction, and that it was unreasonable to interpret it that way. If there are no other questions, I'll rest
Seeing
on
no
my brief.
questions, thank you both for your arguments. Very interesting case, about 7 words. And with that, I'd like to thank our court officers and our law clerks and court staff for their assistance in today's session, and we are adjourned.